golden rule is defined as a basic principle which should always be followed by an individual or a group to ensure success in general or in a particular task. Next, we will explain on 5 rules of advocacy that need to be acknowledged by the law students. First, a lawyer shall fearlessly uphold the interests of his client without any regard to any unpleasant consequences. Be courageous on behalf of the client using all the proper weapons but not improper weapons. A lawyer should not act in a way that would put the administration of justice and the community's confidence in the profession at risk. Never take unfair advantage of an opposing party's lack of legal knowledge, nor use your professional status or qualification to take unfair advantage of another individual to advance your client's interests. A lawyer shall refrain any action in which he abuses or taken advantage for his own benefit of the confidence reposed in him by the client. Next, a lawyer should respect and accept the decisions of the court. Do not utter bad or negative words in the court or engage in any personal attacks on the judiciary. Do not unfairly criticize judicial decisions. The best solution is appeal. Avoid all actions that may erode, tarnish, or delay at the administration of justice, and avoid any actions that may lead to the contempt of court.
Advocacy, in the simplest form, means a skill. When a legal advisor puts forward a particular argument to a court with a view to persuading the court to come to a decision favorable to their client, that is advocacy. Next is being honest and straightforward while presenting case. As an advocate, we have to always be honest towards our client and also during the hearing. Here, we have to think through our arguments before presenting. Being honest in advocacy will make a credible advocate, as an advocate is someone who is being relied on by the client. Straightforward here requires us to deliver arguments that are easy to understand. The profession of a lawyer is seen as a craft where we use our skill and reflect it on our writing and advocacy. Hence is why it needs effort and time to make it a perfect craft. Plus, in our written work, we have to weave every argument, paragraph, sentence, word, and how do we do that in a way that is easy to be understood by another? Here is where we have to maximize persuasiveness and also take note of clarity. Being persuasive does not necessarily mean the argument have to be lengthy. The arguments should be kept simple in order for it to be easily understood. Now, one of the golden rules in advocacy is to be a good and respectful opponent. In advocacy, we have to set in our mind that what we are fighting with is the issues and not personalities. In order to do that, an advocate have to carefully examine the opponent's credibility. Go through their evidence that they rely on. Go through include reviewing the cases, analyze them, and so on. This can ensure that we win the battle with and therefore of credibility. Thus, we have to be reasonable in handling our opponent. We shall also not forget to recognize that there are legitimate differences of opinion and the same applies to our opponent and us.
A good advocate is a good listener. An advocate must have a quick mind so that he can listen to the judge's commands closely and react quickly. Other than that, the advocate also have to have an understanding heart and charm of personality, since he has to understand another man's life story and catch up with a client's or witness lifelong experience, which most of them are from another profession, and this process sometimes have to be done overnight.
The definition of decorum is proper behavior. Proper behavior in a trial means behaving formally with an emphasis on courtesy. Everyone in the courtroom must be treated with courtesy and respect, including the court reporter, the clerk, the prosecutor, the judge, and the witnesses. Having good court etiquette entails dressing well, acting well, and behaving in a responsible manner. Therefore, here are some proper behavior that should be adopted before, while entering, and when we are inside the court, as well as proper ways to address the court. there are a couple of things that we need to mind before entering the court. Firstly, be punctual and arrive on time. Make sure you arrive well before your hearing time, at least 15 minutes earlier than your actual hearing time. Arriving early is much better than arriving late, and a late arrival will be seen as being utterly disrespectful. Next, dress appropriately. Court proceedings are formal occasions, so wear clothing that will be appropriate for court's hearing. Court is not a fashion parade, and bright colors and patterns can be distracting for the judge. Next, be ready. What is it meant by being ready is firstly to know the courtroom and the time your matter is due to be called. Have your papers in order, tabbed, and readily ascertainable so they can be placed on the bar table quickly, quietly, and efficiently. Be nearby and alert to the call of your case by the court officer or associate. Most importantly, turn off mobile phones and electronic devices before entering the courtroom. Or at least you can switch phones and electronic devices to silent mode. Remember, vibrations can be audible and annoying, especially when the phone or device is resting on the bar table. Hence, it might bother the whole hearing session. So, make sure to be careful and check your electronic devices first before entering the court. Moving on to the proper behavior while entering the court. The first thing that we have to remember when entering the court is to be silent. If there is a hearing in progress, those parties are entitled to have the judge's full attention without distraction by your bustling entry. Besides, the courtroom is likely to be live, and any remark you make will be digitally recorded. Other than that, make sure to bow respectfully to the judge. If the judge is already in the court when you enter, stop and bow respectfully to the judge from the doorway of the court before proceeding to your seat. The bow is by a respectful and measured nod of your head and shoulders. It is neither amusing nor respectful to bow too low and deep or quick and shallow. You might get bored while waiting for your case to be called. However, you need to make sure to reduce conversation to the bare minimum, quietly, and only when necessary. Joking, sniggering, laughing, and facial reaction must be avoided at all costs. Or even better, you can go outside to the court if you need to talk. Remember that the judge can see and hear you.
In the next part, we will be discussing on the stage of addressing the court. Firstly, the judge is the main focal point. The judge not only represents the ultimate authority in the court but also the law. So what are the things that practitioners should do are rise immediately when the judge enters and leave the courtroom. They also should remain absolutely silent with complete attention until the judge takes his or her place. Secondly, announce your appearance in a clear and respectfully loud voice and in accordance with the court protocol. For example, a solicitor might say, "May it please the court, my name is Afiqah Syahirah Muhammad Salleh, solicitor of Abu Bakar, and I appear for the appellant." Anyway, avoid familiar introductions like "Good morning, Your Honor." Thirdly, address the judge politely and respectfully. Never address the court in second person, for example, you. Remain polite to the judge, opposite counsel, and court staff. Stand promptly when speaking to the judge and do not interrupt or speak over others while they are talking. Fourthly, use an appropriate oratory tone, pace, and volume. But how to do that? First, don't speak too rapidly. Your speech will become blurred and indistinct at above 200 words per minute. Second, annotate your notes to prompt you to slow down or speak up. In the next part, there are also several tips to behave in the courtroom. Sit up straight with good posture. Do not slouch, rock, or lounge at the bar table. There is nothing impressive about looking like the disinterested, lazy, and recalcitrant kid in the schoolroom. Remain in attendance until excused. The bar table must never be left unoccupied during the hearing of a court list. You should remain at the bar table until excused by the judge or until the next matter is called or until the court adjourns. Thirdly, move papers and take notes quietly. It is acceptable to take notes when another is talking, but be judicious with your notes and you do not need to record every word like a transcription service and become noisy and exasperated attempting to do so. Further, noisy paper flipping and movement of books, etc. at the bar table is discourteous and will display an affront to the judge, witness and your opponent. It is rude. I think that's all from us. Thank you. Have a good day.